Good afternoon, Your Honors. This is case number IT-0265/1-S, the prosecutor versus Predrag Banović.
And may we have the appearances?
May it please Your Honors, Sarita Chana for the prosecution, assisted by case manager Ruth Copper.
Thank you.
Yes, I'm Jovan
Banović, attorney at law from Novi Sad. I'm representing the accused Banović Predrag.
Thank you, Mr. Babic. This hearing is for the trial chamber to deliver the sentencing judgment in this case. What follows is a summary of the written judgment and forms no part of it. The written judgment will be made available to the parties and to the public at the end of this hearing. At a hearing held on June 26, 2003, the accused pleaded guilty to count 1 of the Consolidated Indictment, persecutions, a crime against humanity, punishable under Articles 5H and 7.1 of the Statute of the Tribunal. The accused's plea was made pursuant to a plea agreement between the parties dated 5th June 2003. In the agreement, the prosecutor agreed that following the plea of guilty and conviction, it would seek leave to withdraw, with prejudice, all other counts, criminal responsibility, and allegations against the accused not set out in the plea agreement. The trial chamber has accordingly dismissed all other counts against the accused, as well as criminal responsibility for the acts of others as pleaded in the indictment. A sentencing hearing in this matter was held on the 3rd of September 2003, during which the parties expanded on the arguments set out in their respective briefs regarding factors to be considered in determining sentence. Both the prosecution and the defense requested that the trial chamber impose a sentence of 8 years. The trial chamber adjourned the case to consider sentence. A written factual basis for the crime and for Mr. Banović's participation in it was filed with the plea agreement. The factual basis was agreed by the accused with his counsel and forms the basis upon which the trial chamber will determine sentence. The facts described therein are as follows. The case against the accused covers events which occurred in the municipality of Prijedor, located in the northwestern region of Bosnia and Herzegovina. Following the overthrow of the municipal government of Prijedor during the summer of 1992, Bosnian Serb authorities in the Prijedor municipality unlawfully segregated, detained, and confined large number of men, women, and children in 3 major camps, one of which was the Karaterm camp, located in a ceramic factory on the eastern outskirts of Prijedor town. It is said that these events were organized and directed by Bosnian Serb authorities in order to carry out a part of the overall objective of the joint criminal enterprise of the Bosnian Serb leadership, namely the permanent forcible removal of non-Serb inhabitants from the Prijedor municipality with the aim of ensuring the creation and control of a separate Serbian territory within Bosnia and Herzegovina. The Karaterm camp began operating on the 23rd of May 1992 and held as many as 1,500 detainees. This camp, amongst others, was operated in a manner designed to ill-treat and persecute non-Serbs from Prijedor and other areas as a means to rid the territory of or to subjugate those who remained. Interrogations, severe beatings, sexual assaults, and killings are said to have taken place on a daily basis at the Karaterm camp. Living conditions were brutal and inhumane. Predrag Banović was a guard at the Karaterm camp between the 20th of June 1992 and the 6th August 1992. The participation of the accused in the joint criminal enterprise was limited to his activities within the Karaterm camp, which included participation in beatings and abuse of detainees. Detainees at the camp suffered brutal, inhumane, and degrading conditions during their confinement, in addition to humiliation, harassment, physical and psychological abuse. The factual basis also describes the deplorable living conditions at the Karaterm camp. The rooms were overcrowded, detainees often lacking space to lie down or move about. Detainees had no change of clothing or bedding and limited medical care. They were fed grossly insufficient portions of food and had limited access to water. Toilets and personal hygiene facilities were inadequate and in extremely poor condition. The detainees had no opportunity to exercise and were not permitted to go in the open area for fresh air on a regular basis. Karaterm authorities, as well as visitors, regularly subjected the detainees to severe beatings, interrogations, cruel and humiliating treatment. Many were killed. The beatings often took place in full view of the other detainees and were accompanied by humiliating and derogating comments. The beatings caused serious physical and mental harm. Insufficient or no medical care was available after the beatings. Many detainees did not survive the camp. The accused was a guard and did not hold any rank at the Karaterm camp. However, he knew of the system of ill treatment in the camp, participated in the mistreatment and beating of detainees in the camp, and intended to further this common concerted system of ill treatment. The accused, amongst others, took part in the beating of detainees at the Karaterm camp, resulting in their death. Specifically, the accused has acknowledged being responsible for participating in 5 murders listed in the factual basis and the written judgment. In addition, the accused acknowledges his participation in the beating of 27 others. Turning to sentencing factors, the trial chamber first considered the gravity of the offense, bearing in mind that this requires taking account of the particular circumstances of the case, as well as the form and degree of participation of the accused in the crime. The prosecution has submitted that in the present case, the underlying offenses of the crime of persecution, to which the accused has pleaded guilty, namely 5 murders and 27 beatings of prisoners incarcerated at the Karaterm camp, are inherently grave. Conditions of detention at the camp were described as brutal, inhumane, and degrading for all prisoners. The accused is said to have abused his position as a guard at the camp by subjecting prisoners to gratuitous and constant humiliation, harassment, and violence. The trial chamber observes that the crime of persecution is inherently very serious. Its unique character is derived from a requirement of a specific discriminatory intent, on account of which the crime is regarded as a particularly serious offense. In this case, the gravity of the offense is demonstrated by the persecutory acts for which the accused has been convicted, namely the murder of 5 prisoners, the beating of 27 detainees, and the confinement in inhumane conditions, harassment, humiliation, and the psychological abuse of non-Serbs detained at the Karaterm camp. The trial chamber accepts that these acts, considered either separately or in combination and examined in their context, are of the utmost gravity. The parties have agreed, and the trial chamber is satisfied that the imprisonment and confinement of non-Serbs in inhumane conditions at the Karaterm camp was carried out with the intent to discriminate against non-Serb detainees. The direct participation of the accused in the perpetration of these crimes, as well as his presence when others committed the crimes, with his knowledge, are factors that the trial chamber has considered in determining sentence. The defense has submitted that in assessing the gravity of the crime and the role of the accused, the trial chamber should take account of a number of other factors. First, the low rank of the accused. Secondly, the state of mind of the accused, who it was submitted never intended to kill anyone. And thirdly, the effect of the aggressive wartime propaganda on the accused. The trial chamber is unable to accept the submission that the low rank of the accused is relevant in assessing the gravity of the offense in this case. The fact that the accused was a low-level offender in terms of the overall structure of authority at the Karaterm camp or in Priador cannot alter the seriousness of the offenses for which the accused has been convicted or the circumstances in which he committed them. As to the state of mind of the accused, it cannot be said to alter the gravity of the offense. The trial chamber is further satisfied that the accused participated in those beatings with the intention to inflict serious bodily harm or the death of the victims. The third issue, the role of the war propaganda, clearly does not affect the gravity of the criminal conduct of the accused and is more appropriately considered in relation to mitigating factors. The prosecution has argued that in assessing the gravity of the crime, the trial chamber should also consider the status of the victims, including their health. The trial chamber accepts that this element affects the seriousness of the offense. The fact that the detainees were civilians who had been in detention for up to 3 months is relevant to the gravity of the crime. However, the status of the victims as civilians does not necessarily aggravate the offense, since the crime of persecution for which the accused is convicted includes the civilian character of the victims as an indispensable legal ingredient. The trial chamber also accepts that the position of inferiority and the vulnerability of the victims, as well as the context in which the offenses were committed, are relevant factors in assessing the gravity of the offense. Turning next to aggravating factors, the prosecution submitted that the vulnerability of the victims and the fact that the accused abused his position while on duty should be considered in aggravation. While the trial chamber accepts that the vulnerability of the victims and the circumstances related to the offense may be considered in aggravation, It considers that these factors have already been taken into account when assessing the gravity of the offense. However, the fact that the accused abused his position of authority over the detainees while on duty, mistreating and beating them, in total disregard for human life and dignity, is an aggravating factor in this case. Turning next to mitigating circumstances, both the prosecution and the defense submitted that the guilty plea and acceptance of responsibility should be considered in mitigation of sentence. The defense additionally submitted that the accused's rank and subordinated position in the police authority, his character, personal circumstances, and behavior in the detention unit should be considered in mitigation. The trial chamber observes that an accused's substantial cooperation with the prosecutor is the only mitigating circumstance expressly mentioned in the rules. In turn, the determination as to whether an accused's cooperation has been substantial depends on the extent and quality of the information that he or she provides. In the present case, the prosecution accepts that there has been some cooperation and promise of future cooperation. However, it argues that the level of cooperation may not be qualified as substantial. On the other hand, the defense submits that the accused has provided substantial cooperation by his plea of guilty, interviews with the prosecution, and a promise of future cooperation. Trial chamber observes that cooperation with the prosecutor is generally considered in mitigation of sentence. But it does not follow that failure to cooperate is an aggravating circumstance. In this case, the chamber notes that the accused agreed to be interviewed by the prosecution, thus demonstrating his willingness to cooperate. The information given in the interviews and his commitment to cooperate with the prosecution in the future, under conditions stipulated in the plea agreement, are factors that the chamber has taken into account in concluding that his cooperation was substantial and thus qualifies as a mitigating factor. The chamber has already examined the low rank of the accused when considering the gravity of the offenses. But the chamber is not satisfied that the accused's low rank in the police force is a factor that ought to be considered in mitigation. There is further no evidence that the accused acted under any form of duress. The chamber accepts the defense claim that the accused has been cooperative and well behaved while in the custody of the tribunal and has taken this factor into account. A trial chamber has the discretion to consider any other factors which it considers to be of a mitigating nature. Dealing first with the guilty plea, the chamber accepts the proposition endorsed in several cases before the tribunal that a guilty plea should, in principle, be considered in mitigation of sentence. Undoubtedly, a plea of guilty contributes significantly to the tribunal's fundamental truth-finding mission. A guilty plea also results in a public benefit when, as in this case, it is entered before the commencement of the trial, as it saves the tribunal the time and resources of a lengthy trial. The chamber thus finds that the accused should receive full credit for his plea as a mitigating factor. And the chamber is also satisfied that the statements made by the accused, both during the interviews with the prosecution and at the sentencing hearing, reflect sincere remorse. Next, the Chamber is required to take into account factors pertaining to the individual circumstances of the convicted person. The defense submitted that the age and family circumstances of the accused and the fact that he does not have any prior criminal convictions should be considered in mitigation. The Chamber observes that in certain cases, age has been considered a relevant factor in mitigation of sentence. In this case, the Chamber notes that the accused was 23 years of age at the time of the offenses. Prior to the conflict, Predrag Banović worked as a waiter. Several statements submitted by the defense attest to the good character of the accused before the war. Shortly after the beginning of the conflict in Priador, the accused was mobilized into the police force and subsequently assigned as a guard at the Karaterm camp. He was not very experienced and received no training prior to this assignment. The trial chamber has considered these factors, together with the lack of any prior criminal conviction, to be relevant in mitigating the penalty. But the chamber wishes to emphasize that these factors cannot play any significant part in mitigating the sentence. The chamber has taken into account as a mitigating factor the fact that the accused is now married and has a child. The chamber does not consider it appropriate in the present case to mitigate the sentence of the accused on the basis of the submission that he was of below average intelligence and showed signs of emotional immaturity. And the chamber is further not satisfied that the accused suffered from any form of mental disability that could be considered a mitigating factor. Nor does the chamber accept the argument that the accused did not have the strength of character to resist the war propaganda. As already stated, the accused committed very serious crimes. There is no evidence that he was acting under duress. The chamber is satisfied that the accused participated voluntarily in the mistreatment, the beating and killing of detainees at the Karaterm camp. The defense has submitted witness statements that indicate that the accused had assisted some individual detainees when approached with particular requests from relatives and friends. There are also statements that indicate that the accused helped some Bosnian Muslims and other non-Serb families during the war. Although these acts may not be said to have impacted in any significant way on the welfare of the non-Serb detainees at the Karaterm camp in general, they do mitigate the criminality of the accused. The trial chamber has considered and weighed all the relevant factors in determining sentence in this case, including the gravity of the offense, any aggravating circumstances, and mitigating circumstances. The chamber has also considered the relevant purposes of punishment, as well as the general practice regarding prison sentences in the courts of the former Yugoslavia. Under the plea agreement, the parties have jointly recommended that a sentence of 8 years be imposed. The chamber is not bound by this agreement. The offense of persecution is made all the more serious by considering the underlying criminal offenses. The accused has acknowledged his direct personal involvement in inflicting severe pain and bodily harm through violent beatings of detainees at the Karaterm camp. More significantly, Predrag Banović has been convicted for participating in the beatings that caused the death of 5 detainees and the beating of 27 others. And any sentence must necessarily reflect this factor. The trial chamber has found that the accused abused his position while on duty at the camp, mistreating and humiliating detainees in total disregard of human life and dignity. The fact that he was a low-level offender in terms of the overall structure of authority at the camp cannot alter the gravity of the offenses for which he has been convicted. On the other hand, the chamber has taken into account all the relevant circumstances in mitigation of sentence. Let the accused stand. Predrag Banović, the trial chamber, having given due weight to the various factors set out in this judgment, sentences you to a term of 8 years imprisonment. The sentence will run as of today. You have been detained in the detention unit for a total of 716 days to date, and you're entitled to credit for this period of time. You will remain in the custody of the tribunal pending finalization of arrangements for your transfer to the state where you will serve your sentence. The hearing is adjourned.
All right. Fru Voulez-vous?